If you've ever wondered what happens after arrest in Kenya, especially when you plead guilty or plead not guilty, or when you appear in court without a lawyer, then this video is for you. I am a Kenyan magistrate, and today I want to explain to you the criminal procedure in Kenya in a simple and practical way. Hi, welcome back to Lifestyle with Nafula. My name is Lubia Nafula. So before we begin, let me clarify something important. This series does not constitute legal advice. It is meant to explain in simple terms what is provided under Kenyan law. For legal advice specific to your situation, please consult a qualified advocate. All right? Now that that is clear, let's go into the topic. So what does an arrest really mean? So when someone is arrested in Kenya, it does not automatically mean they are guilty. What it actually means is that the police suspect that an offense may have been committed, and investigations are underway and investigations are ongoing. So at the point of arrest, the law requires that a person must be informed why they are being arrested. They must be informed of their right to remain silent and informed of their right to an advocate. These are constitutional rights and not favors. The second aspect is that in Kenya, there's a 24-hour custody rule. So what does this rule entail? After arrest, the police cannot hold you indefinitely. You must be brought in court within 24 hours of arrest or on the next working day if you are arrested on a weekend or on a public holiday. If this does not happen, then that detention is deemed as unlawful. So when you appear in court, on your first court appearance, this is what happens. At first, the court will usually confirm your identity. This is done by calling out your name, to which you respond, and you can say this is your name or this is not your name. Your name has been mistaken. Usually clarifications are made to ensure that it is the right person who has been presented before court. The next procedure will be for your charge to be read and explained to you. So the charge is the offense for which you're being charged. Your charge is the offense for which you're being charged. So for instance, if you're being charged of stealing, you'll be told that you're being charged of stealing. It will be explained to you the particulars of the offense, that on such and such a date, at such and such a time, in such and such a place, you did ABCD, which amounts to stealing. All this is explained to you, of which you're expected to plead guilty or not guilty. Yani umekubali mashtaka ama umekataa mashtaka. If you plead guilty, let's start with what happens if you plead guilty. So before I go there, this is usually the most confusing moment for many people. So let me explain maybe before I go in what each option actually really means. So if you plead guilty, what it means is that you're telling the court you have accepted the charge as read and as explained. So the court must first be satisfied that you understood the charge, your plea was voluntary, it was not coerced, and you're not being forced or threatened. Then if this plea is clear, then the court will record a conviction. Or if it is not clear, the court will record not guilty. But if it is clear, the court will record a conviction. Then they will hear the facts as presented by the prosecution and accept the evidence that is tendered into court. But the court may also refuse the facts and the evidence if they do not match the offense for which you are charged. Then thereafter, you are going to be allowed to mitigate. Now, mitigation means kujitetea. You will usually hear, you will usually be asked utajitetea aje. So these are circumstances that will allow the court maybe to reduce your sentence, you know, or give you a lenient sentence. So some of the things that you can say is maybe if you are a mother, or if you did not intend to commit the offense, or if you're sorry and remorseful for the offense, if you are a first-time offender. So this is the place where you explain all these things. Now, after mitigation, the court then proceeds to sentencing, where you're given a sentence. Now, pleading guilty sometimes leads to a lighter sentence, but it also means you give up on your right to go to a full trial, and most of the time you cannot overturn a sentence or a conviction once you plead guilty at the initial stage without going to full trial. So you have to be very, very aware of it, and you should not do it out of confusion, out of fear, or out of frustration. So what happens next if you do not plead guilty? So if the charge is read to you and you do not plead guilty, then you're saying you do not either you do not accept the charge, you do not accept the offense, or you may accept the offense but you do not accept the particulars as they have been read. For example, you can be accused of assault, yani ulimchapa mtu, but in your defense you say no, sikumchapa, tulipigana. So it means that you are accepting to some level that there was a physical encounter between physical aggression between you and someone else. However, you're saying the other person equally retaliated. So that offense is actually called affray, kupigana, affray. In that case, the court enters a plea of not guilty. So, and this begins the trial process. So the court will then consider bail or bond and then give directions. At this stage, the prosecution is required to give you witness statements and to give you access to all evidence that they intend to use during trial. Then, once the court has confirmed that you have all the documents that you need, you do not need to give any documents to the prosecution, but the prosecution, because at this point, you're still innocent until proven otherwise. So the prosecution gives you the documents, all the evidence they will need to prepare for you, to enable you to prepare your case. And then the court gives you directions and schedules for a hearing day. So pleading not guilty is your constitutional right, and it does not offend the court. You can plead guilty. It does not offend the court at all. It doesn't. So if you have no lawyer and you do not know what to do, and this is usually the very common thing, you are not really required to have a lawyer in order to appear to court, although it is your right to representation. So if you are unrepresented and unsure, usually the court is expected to explain the charge in a language that you understand, and that is why most of the time the courts will use Swahili. The court will explain your options, then the court will give you time to think and inform you about legal aid where applicable. So for instance, a crime like robbery with violence, a crime like defilement, a crime like rape, those are crimes that carry very heavy heavy penalties. So sometimes people will come and plead guilty. And then utasikia koti ikisema utarudishwa remande, to mean you'll be taken back to remand, to give you time to think as to whether that is the plea that you want to take. If you plead guilty, that is what the court will do. This is to ensure that you're pleading guilty with a clear mind, because the court really wants you to understand that the weight of the offense is so heavy, and once a conviction is entered, there is no point of return, as I've already explained. So they give you time to think about it, then come back and tell the court whether you actually plead guilty or not before the matter can proceed. So the court will usually explain the charge in a language that you understand, explain your options, give you time to think, and will usually inform you of legal aid where applicable. One of the most common places you can get legal aid is there's the legal aid department in the office of the Attorney General, and there's also Kituo cha Sheria. Now, you are allowed to tell the court, I do not understand the charge, and the court will explain it to you until you understand. You can tell the court that you need to seek legal advice, and you can also inform the court that you're not ready to plead in all of these circumstances, because your rights, especially your right to liberty, is at risk. The court will indulge you at that particular stage unless it believes that you are engaging in delay tactics. So after that, you are entitled to bail or bond. So in Kenyan terms, bail usually refers to, both of them are the same thing, but in common Kenyan terms, bail usually refers to cash bail, where the court directs you to pay a certain amount of money into the court to secure your court attendance. And bond, you're usually required to provide security such as a title deed, a logbook to a car, motorcycle, maybe deposit a valuable item into the court, such as your passport, to ensure that you're not going to run away and you're going to attend court. So after the plea, so your bail is your constitutional right, unless there are compelling reasons to deny it, such as the risk of absconding, interference with witnesses, and also taking into account the seriousness of the offense. Bail may be denied, but it does not mean that you're guilty. So this series exists because I've seen how fear comes from not understanding the processes. I've seen people being taken advantage of for not understanding processes. So this series is to explain what the law provides plainly, calmly, and respectfully, because the law affects real people and real lives. So if this video has helped you understand albeit a little bit, criminal procedure in Kenya, please like, please subscribe, and share it with someone who may need this information. Also, let me know in the comments what part of the criminal justice process, or just what part of the court justice process, would you like me to explain next. Thank you for watching Lifestyle with Nafula. Until this is law explained simply, not legal advice. Once again, I'll see you in the next video. Bye bye.